Hello, everyone. I want to have a quick chat with you about shareholders agreements. When we're looking to start up a new business, a new corporation, and there's more than one partner involved or more than one shareholder involved, it is incredibly important for you to have a shareholders agreement between the shareholders. Now, is this legally required? No, not at all. You can let the articles dictate the day. You can rely on the BC Business Corporations Act on its own and hope that nothing happens between the two shareholders that falls outside whatever you've added to your articles. But the reality is issues can arise, and there's certain pitfalls that are so common to most businesses. It's better to address them through a shareholders agreement instead of spending tens of thousands of dollars, if not hundreds of thousands of dollars in court when things go awry between shareholders. So in my practice, I've been working with smaller companies, entrepreneurs for a very long time, and I've yet to have clients come back and say, geez, we really wasted our money on that shareholders agreement. It's never happened. Now, what I do hear from clients commonly is, I wish we had done a shareholders agreement 2 years ago or 3 years ago. And this usually happens when they're embroiled in some nasty shareholder dispute. All right, spending those 3 or 4 hours with a business lawyer, figuring out what it is that you want in a relationship with the other shareholders, how you want to run the operations, and so forth is incredibly important and will save you a whole slew of money in case there is a conflict in the future. Now, many times the best agreement is the one that you draft and you put in a drawer and you never look at again. But if you do need to refer to something 1 or 2 years down the road, it's there for you, and you don't get embroiled in court action or litigation for many of these disputes, which can be easily addressed in a shareholders agreement. Now, I'm going to go over a few points and a few things that you would discuss in a shareholders agreement. I've made some notes, so I apologize if I'm looking down more often than I normally do in these videos. But I think you'll find it useful, and I think it'll give you some ideas that you may want to discuss with your shareholder and with your shareholder partners, and maybe make an appointment with a business lawyer to help draft something to address these particular points. So a few of the things that you want to look into are, what happens if shareholders aren't getting along? What if two shareholders want to run the business one way and one of the other shareholders is completely at odds with them? Well, a shareholders agreement can help address those points. Also, what do you do when one shareholder wants to sell his or her shares and the other two shareholders do not? Is that lone shareholder allowed to sell their shares to anybody that they please? Or do we want to incorporate right of first refusal provisions and perhaps some other provisions to limit or restrict the ability to transfer those shares out? And the same holds true for if an offer is made to a company by a potential buyer and the majority of the shareholders are keen on selling the company, but then you've got that one shareholder who is refusing to play ball. Are there things that we can do to address that situation? Definitely. We can paper provisions into the contract to drag along that that one shareholder who is not playing ball and essentially force him or her to sell their shares. Now, one of the other points is your company, when you're starting out, is going to be working in a particular industry and may have a particular business focus. Over the course of time, you may find that one or more shareholders want to diverge from that original objective. Are they allowed to do that? Does the company have to move in that direction? Again, these are things that can be addressed in a shareholders agreement. Similarly, life situations happen. What happens if one of the shareholders dies? What happens if a shareholder gets disabled and is no longer able to contribute to the company? Now, this usually not an issue with publicly traded companies where you have hundreds of shareholders, or even very large privately held companies where you have 40, 50 shareholders. But it is an issue when you have smaller companies where the shareholders are actually key persons to the operations of that business. Generally speaking, when you have closely held companies, you don't really want someone's estate to jump in and start playing a role in the decision making of that business. There's key persons are involved because they add value to that business. So if a particular shareholder becomes disabled or dies, the company in most cases will want to buy those shares back and offer fair market value for those shares to the estate, as opposed to allowing the estate to take control of those shares and now have a seat at the board and make decisions when really that estate is adding no value to the company and to the operations of the company. Now, again, just on that same note, what happens if a shareholder goes through a divorce? It's possible for the shareholders X to make a claim for those shares, and that is a situation you do not want to be in. Properly drafted provisions in a shareholders agreement can address that situation. Some of the other things that should be addressed, that can be useful to address in a shareholders agreement, are funding for the corporation. Well, how are we actually going to fund the operations of this business? Now, in the beginning, it may well be that you have enough funds to get the basic operations off the ground. But over time, as your company grows, you're going to require funds to keep the ball rolling. When that happens, will the shareholders be obliged to put in their share of the capital needs? There's ways to structure it so there is a flow of how that funding is to be provided. For example, maybe the first route is from the company's own reserves, from the company's own profits that are generated year after year, that those will be used. Then through debt financing via lending institutions. And then third, by shareholders providing loans to the company. And then are those loans going to be mandatory? Like, must the shareholder make them? Or will they be optional to the shareholders? And if so, how does that actually work? Along with that, there's the question of if you're in a particular industry, will shareholders be allowed to work for competitors in the same industry? Or can shareholders go ahead and solicit clients of the jointly owned company for their own purposes? It can be quite useful to have non-solicitation and non-competition provisions baked into the shareholders agreement. That can help you avoid a lot of heartache down the road. And it's understandable when you're starting off a company. You're doing it with good intentions. You get along with everyone that's involved, and you're kind of in the honeymoon stage of your business. Everything is roses and unicorns. But as your company grows and as you push forward, issues will arise. And these won't be small issues. These can be very significant issues that you do not want to have to go through court or the litigation process to resolve. If you can, sit down with a business lawyer. At the same time as you're incorporating a company, put together a shareholders agreement. I have yet to have a client who has sat down, put together a shareholders agreement, and regretted the time and or money involved in putting it together. It's always the other way around. If you have any questions regarding shareholders agreements or any other matters pertaining to your company, feel free to give us a call back at 778-565-4700.